next case before us is Orion Management Inc. versus Brittney Kaeka et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of time. Also, there's a cross appeal in this case. That does not change our procedure with the time. The appellee can respond to the appellant and also argue the cross appeal in the same 15 minutes. You may choose to allot your time however you like on those issues. Also, the appellants have the same amount of time, 15 minutes, and a rebuttal time, and you can allot your time how you'd like to allot your time with regard to those issues. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child if that applies in this case. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honors. Ronald Skingle on behalf of Orion Management Inc., appellant and cross appellee. I'll reserve 5 minutes in rebuttal so I can address the issues within the appellate's brief. May it please the court, Your Honors, this is a case involving breach of contract, as it's indicated in the briefs. It's a home construction services contract. There was a trial in front of Patricia Cosgrove for almost 2 weeks. The one issue I would address first is my first assignment of error really is the issue with regards to the insurance payments that were received by Kaeka. I'm going to use the party's name just to make it easier instead of appellant. That they received based on their insurance company. The work was never completed, and as you can see in the factual statement of my brief, the work was never completed. They received insurance payments, which completed the rest of the work. The main issue at trial, or one of the main issues, was whether the roof pitch was either 6 by 12 or 4 or 3.5 by 12, and there was, as you saw, a lot of expert testimony as to that specific fact. But the overriding theme throughout this entire trial was these insurance payments. Now, the Kaeka Latham had filed a motion to eliminate, to exclude the mention of any receipt of insurance payments at trial, and those were excluded under 403, evidentiary rule 403. But this issue was reoccurring. There were issues in regards to in chambers, sidebars over this issue of payment of insurance throughout the entire trial. Basically, and as the court knows, the standard in this case, with regards to a breach of contract, is to cover the cost of repairs as well as put the party in the same position it would have been if the contract was performed. And as I indicated in my brief, the collateral source rule enables insurance payments in breach of contract actions to come in to offset that. And the issue that we have here is that the trial court initially said that's not relevant, or if it's relevant, it's outweighed by the substantial prejudice. However,
Appellee argues, I'm sorry.
Go ahead. So that's what.
The response to that argument is that that wasn't proffered on the record.
Correct.
What's your response to that?
First of all, within the record, if you look, I think it's at the end of the trial, there was discussions between myself and the court with regards to that very issue of the insurance payments. I requested some kind of set-off hearing. We had discussed that earlier in the trial in chambers, and I believe that what the court's position is that they were going to allow me to file a judgment notwithstanding the verdict, motion for new trial to address that issue. It even says in the record that it doesn't matter, according to the court, and I'm quoting, it doesn't matter which vehicle we use to address that issue of the insurance payments, but as long as we address the issue.
But counsel, whenever I read that, I also thought that you could just read the court's instruction to counsel as the vehicle to get the issue before the court, not not to get proffers before the court.
Well, the issue is before the court, the entire trial.
Well, was there anything in the record, and going back to what Judge Lanziger said, anything in the record where you tried to put on the evidence or you proffered what the evidence would be?
Yes, during the I believe the testimony of one of the, either Kaeka or Latham, there was discussion with regards to payments made by the general insurance adjusting. And basically, just for clarification, what that was is after Orion was no longer on the job, their new insurance adjuster came and started doing, I guess, an estimate or a new scope and determine what that work is. They submitted into evidence payments made to that general adjuster or that insurance adjuster, as well as other evidence that insurance proceeds were used to.
So you're saying that in the briefs, they call them consumers, so I'm just gonna use that right now.
That's fine.
I mean, I understand that there's an issue about whether they were consumers or not, but
Correct.
regardless. If you're saying they actually introduced evidence of the insurance proceeds themselves,
That's correct. And
well,
I
then
said,
the issue really was in front of the jury, right?
no, because what happened was, is as I raised that issue or tried to cross-examine on that, the trial court judge stopped me
Right. But the
pursuant
jury,
to objection. So that was forestalled at that point. And then when we went to discuss the issue of insurance, that was the vehicle in which I was instructed to be to pursue that particular issue. If it wasn't, that's what the trial court wanted. So that's what I did.
was there a jury instruction that they're not to consider insurance?
I believe there was. Because that was, I'm just gonna let you know, that issue probably came up 5 or 6 times during the course of the trial.
Okay.
And that was, they were instructed, I believe, if my recollection is correct, they were instructed not to disregard any of those statements. So,
Okay, now I have one more question,
Sure.
and then I'll try to let my colleagues have a chance. In regard to this, whether you agree or not, the jury obviously came back and ruled against your client.
they sure did.
Okay, so one of the basis was supposedly that your client had actually damaged the property and not just repaired it. That was evidence that was presented, right?
How so? What do you mean, like damaged?
Well, I get to ask questions, number one, but number two.
Okay, I'm just trying to
No,
clarify
But
because.
number two, they talked, the evidence was that they didn't tarp right, so there was additional damage that was caused by their negligence or the breach of contract and not tarping correctly, so that there was floor damage, there was damage to their family room, there was damage to this, there was damage to that. That was all caused by your client.
That's correct, and the way it works, though, just so you understand, and the insurance industry and this current scope, this was a complete destruction of the structure, or partial complete destruction of the structure. And yes, it was tarped, rain came in, supplemental scopes are made in all these cases. You know, you just don't have one scope, so yes, there was
I understand, I'm just
damages.
talking about what evidence was presented, and obviously the jury believed some of that evidence.
Yeah, they believe, well, I think they believed, when I ask it, and it goes into my second assignment of error, is the roof pitch. That was the main
Okay.
issue.
Well, let me get into this, this is back, the reason I'm asking these questions are, it's in back to your scope of your assignment area in regard to the insurance
Mhm.
proceeds. So if the jury thought or believed,
Mhm.
found, whatever you want to say, that they believed, the consumers, that there was additional damage because of their shoddy workmanship, insurance companies wouldn't be responsible for somebody's shoddy workmanship. They would only be responsible for what the act of God was that caused it, right?
No.
Okay, so the insurance company would have to pay for the shoddy workmanship of a third party?
If, for example, like the tarp and the water company, of course, there were supplemental scopes made. They existed.
I
They
understand,
covered
but
that,
I'm
yeah.
asking who is responsible for that?
The insurance company would pay that.
Okay, so if somebody came in and just a lousy job, then instead of going after the contractor, the insurance company would just pay everything?
Well,
That doesn't make sense to me.
what I'm gonna correct is there was not an allegation of shoddy work.
Oh, I think there was, wasn't there?
No, there was the roof pitch. That was the main issue. And if the roof pitch was not correct, then the entire structure would have to be taken down. point where work ceased. The framing was up, the pitch was established, pursuant to the architect and the evidence, you can see what that is. That was already up. The job was not done. Now, when you get to the shoddy workmanship, you're talking about the tarp, which resulted in water leakage. All that additional damage would be covered by the insurance scope, by the new additional scope. So what had happened, and just to say, is that the insurance paid for everything. They paid for the completion of the tear down and the reconstruction of the roof with the 6x12 pitch. So that was my argument, saying, yes, it covers the cost of repairs, but you can't get a windfall either. And that's exactly what happened in this case. They were put in the same position as if the contract would have been completed.
Was there any discussion, I know this would have been not appropriate in front of the jury, but was there any discussion on the record in regard to what the insurance policy itself said in regard to reimbursing them?
No, it never got that. So I guess the other assignment of error that, I'll touch on the other ones briefly, is the motion for directed verdict with the contract. And I think this, just to touch on it really quickly, is that they never proved that they were in substantial compliance with the contract. Their argument was that Orion didn't send paperwork to their mortgage company to I guess, start the process for payment. Number one, they refused to sign the authorization to perform services with or disclosure with the insurance company, which automatically made them responsible for getting the payments to Orion. Secondly, they argued that the office manager, Orion, never sent the paperwork. There's testimony in the record indicating that she sent the W-9 and the other accompanying forms. They claim, they cite to evidence in their brief, which is a proffer that they made, that this evidence was never sent.
Counselor, I just want to give you a warning that you are into your rebuttal time now.
Okay, I will stop and I will withhold my 5 minutes for the cross exam. Thank you.
Thank you. May it please the court, my name is Laura McDowell. It is my privilege to represent Brittney, Kaeka, and Brittney Latham, the consumers. I would like to reserve 5 minutes for rebuttal.
You can't reserve time for rebuttal.
Oh, I
You have
can't?
to argue
Okay.
all your issues.
Okay, that's fine.
15 minutes.
In response to Orion's argument, I would simply say that I would like the court to review the statement of facts from our brief of the appellee, and you will see we have cited everything in the transcript, and it is goes against the facts that Mr. Stingle has indicated, and they are all from the transcript, and it is supported by the evidence, and there was no evidence submitted regarding this insurance that he's talking about. That is not correct. We have 3 main points on our cross appeal today. The first is the trial court erred in granting summary judgment on the CSPA claim. The second is the trial court erred in granting summary judgment on the slander title claim. And the third is the trial court erred in granting motions in limine on the Home Solicitation Sales Act and the Home Construction Service Suppliers Act. On the CSPA claim, the CSPA is a remedial law which is designed to compensate traditional consumer remedies, and so must be liberally construed under Revised Code 1.11 that has been repeatedly found by the Ohio Supreme Court. Conversely, exceptions to remedial statutes are to be construed narrowly, and that's what is at issue in this case. Orion seeks to use an exception to the statute to avoid the application of the CSPA. The exception is set forth in 1345.01A, which defines the term consumer transaction and does not include transactions involving a home construction service contract. That exception does not apply here. The question is whether the Home Construction Service Suppliers Act which is revised code 4722.01, applies to new construction only or whether it applies to remodel. Every court that has considered this issue has ruled that the HCSSA applies to new construction only and that the CSPA applies to remodels. We cited the cases in our brief. The two primary cases are the case of Better out of the 11th District and the case of Tomlinson out of the 5th District. And in the case of Tomlinson, the 5th District case, that actually went up to the Ohio Supreme Court. There were three, the contractor made three proposed propositions of law. Number one was residential remodeling services are exempted from the definition of consumer transaction under the CSPA. Proposition of law 2 was the Ohio Home Construction Services Act, rather than the Ohio Consumer Sales Practices Act, applies to transactions involving the remodeling of an existing residential building. And then they had a proposition of law 3, which involved jury trial. And the Ohio Supreme Court rejected propositions of law 1 and 2 and accepted proposition of law 3 and reversed the decision of the 5th District and sent it back to the trial court on the jury trial issue, leaving this CSPA determination in place. So now Orion has not cited a single case where it has been held that the HCSSA, the 4722, applies to remodels and that the CSPA does not apply. There's not a single case. We couldn't find one and they haven't cited one. Now, last year, the Ohio legislature amended the Home Construction Service Suppliers Act to specify that the act now applies to new construction and remodels. The amended law took effect in September of last year. Rules of statutory interpretation support the consumer's argument that the version of the HCSSA that was in effect at the time of the transaction, in this case 2019, does not apply to remodels of existing structures. The version that was in effect prior to the amendment of the statute did not define the word construction. Courts relied on the definition from the Ohio Supreme Court, their definition of the word construction that excluded remodeling from the definition, and the legislature amended it after the decisions in Better and Tomlinson. The legislature is presumed to be aware of the decisions in Better and Tomlinson when it enacted the amendment, and that decision supports the consumer's position that their claim should proceed under the CSPA. The work done in this case was remodel, not new construction, as Orion has now tried to change its position. The Ohio Supreme Court says the definition of construction means the creation of something new and original that, quote, did not exist before. And it's undisputed in this case that the family room existed before the tree fell. And if you look at Exhibit I, you'll see that Orion's application for a building permit to Summit County, when they filled it out, their project description says restoration of family room. So regarding the CSPA claim, it is our position that the summary judgment was wrongfully granted, and we request that that be reversed.
If I recall, in part, I may be wrong with the trial court decision, but didn't they place weight on the fact that this was a cost-plus contract, and therefore it's not a home construction contract, and therefore doesn't apply to this GSPA?
Regarding the issue of the cost-plus contract, I'm going to also indicate that was there was no evidence submitted in the trial court at the time of the summary judgment, or actually at any time, indicating that this was a cost-plus contract.
Was the contract itself admitted as part for the summary judgment ruling?
No. There was no proper evidence admitted at the time of summary judgment. At the time of summary judgment, Orion submitted some exhibits, but did not have an affidavit to support the exhibits, and we objected to that. They submitted a...
Did the trial court grant your objection or rule on it in some capacity?
What the trial court said is that that Orion had submitted the depositions of both Ms. Kaeka and Ms. Latham, and that the depositions had exhibits, but the exhibits weren't attached. And the appellant, Orion, referred to certain exhibits from the depositions, but they weren't corresponding to the exhibits that had been submitted in connection with the summary judgment motion. So, for example, for the summary judgment motion, Orion submitted exhibits 1 through 15, and for the deposition, the exhibits were maybe exhibit 4, exhibit 8, whatever. And so in his summary judgment motion, he's saying it's exhibit 8, but it was exhibit 4 in the deposition. So you see what I mean? It wasn't like he had an affidavit that said, here are these exhibits, and they're authenticated. They were not authenticated exhibits. It was just, going back and forth. And so
Were the depositions themselves and the exhibits admitted, though?
the depositions were admitted, but no exhibits,
Okay.
no.
Okay.
So the exhibits were not attached or admitted.
And they subsequently did do an affidavit, though, right?
No,
Oh, they didn't?
they did not.
I have a question.
Yes,
So this went to the jury on just purely breach of contract.
correct.
So assuming that the court was right about granting summary judgment on the Consumer Practices Act and the slander of title, I can't understand from the record how it didn't, the other claims, the Home Solicitations Act or the Home Construction Service Act didn't get to the jury. There's something about a motion in limine. Can you explain to me how that occurred?
Those were motions in limine.
Right, which involved evidence on those points, correct?
Correct.
So how did we say something about the court treating that like summary judgment? Can you talk about that argument a little?
Yes, I mean, we objected to those motions on the basis that they were being filed as summary judgment motions. They were granted. We submitted evidence on the HSSA at trial because the door was opened by Orion, and we submitted jury instructions and asked the court to
Include that.
and the court rejected it. We feel that the HSSA should have been submitted. It's the HSSA should have, that's a two-part. The Consumer Sales Practices Act is a two-part thing. It applies to solicitation, which that's what this was. This was a storm chaser situation where Orion was on the scene at the neighbor's house trying to get the neighbor's business, and that's how they got these consumers' business. And so that solicitation should apply here. And so the fact that the court felt that the CSPA didn't apply to the main contract, which is, we feel is not correct. And the fact that the court made a finding, I'd like to respond to your question about quickly got out of time here. But on the you asked about about the issue about cost plus contract. There was only one contract. They did not submit any evidence at the stage of summary judgment. But at trial, the owner of the company testified that there was only one contract, and it was this one-page form that said nothing about a cost plus contract. And the consumers filed an affidavit in response to summary judgment saying, we didn't sign a cost plus contract. And in reply, they did a reply brief, Orion did, which was forbidden by the court, and we filed an objection, and it was taken out, but
The court struck it.
But the court's decision was based on everything in that reply brief. So obviously it was accepted. So the cost plus contract, there was no evidence of it, but it was then used throughout it was used for the motions in limine. The court made a finding that this was a cost plus contract, and there was no evidence of it, and then it was used throughout the case to make decisions that, oh, there's a motion in limine. Yep, that's it. There's it. So I would like to move on to the slander of title, just briefly. The consumers submitted evidence in response to the slander of title that Orion was owed nothing. Orion caused more damage to the home than the value of the services it performed. Orion listed on the bill work that it had not actually performed. They knew they had not replaced the rafter that was included on the bill, but they billed for that. In Orion's own specifications, it called for a 6/12 pitch on the family room, but they replaced it with a 3/12 pitch. That deprived the consumers of the cathedral ceiling, which was the whole reason they had bought this house. Yet Orion charged for the more expensive 6/12 pitch. Similarly, Orion charged for high-priced materials listed in its specs. Orion, in the consumer's affidavit opposing summary judgment, the consumer said Orion is entitled to no money at all because the cost of correcting its work was more than the work itself. And an excerpt from Ms. Latham's deposition, she was asked whether Orion was entitled to be paid for the work, and she replied, no, because they caused a lot more damage than what they're asking for. In its brief on appeal, Orion claims that Ms. Kaeka and Ms. Latham acknowledge or admit that they conducted work and they were entitled to be paid, and no, they do not say that. If you look at the pages of sites, that doesn't say that. To support its ruling, under...
let you know that your time is concluded. If you could wrap up in about 10 seconds.
Okay. We are asking the court to confirm the breach of contract rulings, verdicts, and to reverse the summary judgment on the CSPA and slander of title, and to reverse the motions in limine on the Home Solicitation Sales Act and the Home Construction Service. And we would also ask the court to look at the case of Summa Health System versus Beningre, which is 140 Ohio Act 3rd, 780 is from here in the 9th District, 2000, which will show the court that...
Thank you, that's all.
Okay, all right.
You may be seated. You'll have 4 minutes and 9 seconds for rebuttal.
Thank you. I'll address the question that you had, Your Honor, with regards to the two motions in limine and how that played out and why that occurred. The first one was the Home Solicitation Act. That is a Consumer Sales Practices Act claim. And as I indicated in my brief, in conjunction with that home solicitation, you have to have a deceptive trade practice. the court had ruled in the summary judgment previously that the consumer sales practice didn't apply. So therefore, the Home Solicitation Sales Act does not apply. Secondly, with
Well,
regards.
wait. But if that's the case, then why wasn't that granted on summary judgment? In
It
other
was.
words, if they, well, not according to what the briefs say anyway.
Well, the
You would have
claim,
had to file a motion in limine if there was no claim before the court.
that was extinguished with the motion of summary judgment. That is a consumer sales practice.
Okay, so why was it necessary then to have a motion in limine if the claim wasn't even there anymore?
Because that was never filed with the original, so summary judgment. But if you would have done that and say it's reversed and goes back, it's the same issue. There's no consumer sales practices claim, and you would have the same result. But secondly, you have the cost plus issue, and with regards to the home sales, the Home Construction Services Suppliers Act. The reason the cost plus was determined was because they filed, meaning the Kaeka filed a motion for summary judgment on Orion's breach of contract claim. And in that particular motion, they argued that since 472202 A and B, those requirements weren't in the contract, therefore that contract, Orion's contract, was not enforceable. We argued in rebuttal saying, this is a cost plus contract. Here's the evidence of the cost plus contract. It's clear that the contract incorporated the scope, the insurance scope, which had material, labor, as well as profit and overhead, which meets the definition of a cost plus contract. And the court based its ruling and made a conclusion of law in rejecting that, in rejecting Kaeka-Latham's claim that this was in fact a cost plus contract. So what I did was filed a motion in limine to exclude any mention of those requirements because the court has already made a conclusion of law that there was a cost plus contract in place. So therefore, any evidence as to 472202 A and B would just confuse the jury because there's already been a ruling that those two didn't apply.
Now, that ruling, as I recall, in the summary judgment decision, or where was that ruling?
The ruling with.
That was a cost plus contract.
Oh, it was in the motion for summary judgment, denying their motion for summary judgment.
That was my recollection, that was part of the summary judgment.
Correct. And then there was a subsequent motion in limine. So,
Now, appellant, or cross-appellant, I guess, on that issue, says, wait, there was no evidence about the cost plus contract when the trial court made that decision.
I would
What
disagree.
evidence would you say there was?
because the insurance scope was attached to the motion for summary judgment, which is incorporated in the depositions that were also attached and filed with the court. So, again, their insurance company, just to let you know, their insurance company requires that these be cost plus contracts, not Orion. Their insurers has a scope that's uniform throughout the United States and says, these are the scopes you're gonna use, and they approve it. And that's the type of contract that they use. Real quick on the CSPA with regards to Better, that is 11th District Court, as indicated in the court's decision, that does not apply in this case. First, this wasn't remodeling. This was a complete reconstruction of a completely destroyed family room. Secondly.
But it was an existing structure.
What?
It was an existing structure.
Not, it,
The
there was
house
part of it
existed.
existed. Correct.
The house
That is
existed.
correct.
Okay.
But it wasn't remodeling a bathroom like in Better. That's what they were talking about, okay? But anyway, the statute has been amended, not to change the law, but to clarify it. Because Better is the only case besides the subsequent one in the 5th District, which indicates that remodeling is not part of the CSPA.
We actually have about 10 seconds. It says 1 minute, but that was an error.
Oh, that's okay. So I would just stand on that, and I would have them reverse on my claims and not on the cross of council.
Thank you, sir.
Thank you.
Thank you both for your presentations. This court will take this matter under advisement and issue a decision in due course. The clerk, of course, will mail you a copy of the decision on the day it's released. The opinions are also posted on the Ohio Supreme Court website. Thank you again.
Okay, thank you.